You want a jury trial 99.9999%
very
of the time.
rare.
That's what you want. These bench trials
Yes.
exceedingly rare, and they really, I mean, it's going to be very fact specific.
Yes, of the hundreds or potentially thousands of actual clients we've had come through these doors
Maybe
now.
one.
This is the only guy I can think of.
Yeah.
But
we are the Armed Attorneys. Today we have a bunch of fun questions. Your questions we're going to be answering today. A kind of new take on jury nullification, common use questions, traveling across state lines, and should you ever request a bench trial as opposed to a jury trial. But before we begin, show your support for the Second Amendment by hitting that like button. And as always, these are our favorite segments.
these are so good.
Yeah, so
All right.
I'll start.
You will? Okay.
Well, I'll kick it to you. How about that?
Sounds good.
Yes, this is from Patriot 1776. Question on a prior questions about common use. Mark Smith on the Four Boxes Diner. Mark's great channel. Go check him out. Makes an assertion that the common use test is just the easiest. First layer challenge to a gun restriction, but not the only challenge available under current precedent. Considering the very real danger of the common use test being used against gun owners in the Second Amendment, do you agree with this assessment?
Yes. I mean, first of all, I'll say Mark is a hell of a lot smarter than I am. So generally speaking, when Mark makes a call, particularly about minutia of constitutional law, I tend to agree, or if I disagree vehemently, I think really, really hard about my position because Mark is incredibly intelligent. But yes, we had just been talking about how common use is, I think, a dangerous game.
Yeah, it's a double-edged sword.
It's a double-edged sword. But, something that we don't get to do in criminal law, but that these constitutional lawyers get to do all the time is argue in the alternative.
What? I get to say he didn't do it, but if he did it, it was self-defense. Just kidding. I never
you don't get to say
We
that.
don't get to do that.
But I know that it would be great. I would love it if I could present a bunch of alternate theories, but I can't. But civil lawyers get to do it all the time. They get to say, assuming arguendo in all of their briefing. We do not. So, I mean, yes, absolutely. I mean, do you have anything to add about that?
No. To the point of, is the common use test dangerous? Yeah, I think there is some danger there. Is it the only tool in the toolbox? No. There's lots of arguments, lots of different ways to attack infringements to the Second Amendment. So should we be as worried about it? Probably not.
All right, so we've got at James Claire Vaughn 8880. How does a black powder pistol play out when it is not considered a firearm with regards to regulations and restrictions put on firearms, such as walking into places where firearms are forbidden? Richard, what do you get to do with black powder pistol?
You get to carry it pretty much everywhere.
Yeah, I mean,
now
your
the police are going to
state's law,
yeah,
your state's law,
may vary.
withstanding.
But we look at, hey, what qualifies as the definition of a firearm? Well, there's a huge carve out from this. Antiques, relics, things that were designed and manufactured between 1898.
Yeah, before 1898, or replicas of
firearms that were designed and made. And it hinges on, these can't be traditional centerfire firearms. They have to be black powder, muzzle loading firearms. And so we just say, hey, by definition, these things aren't firearms. So that's the federal law. Now, your state law probably has something similar. I would check that out, though, confirm that. But if it's not regulated as a firearm, well, great news. All the gun laws theoretically wouldn't apply to this. But keep in mind, still going to be considered a deadly weapon. Still going to be considered a weapon for purposes of like trespassing.
Yes.
Or if you have statutory provisions in your law that says you can't bring a weapon, and I'm sure it has something all encompassing there, maybe it falls under a general weapon category as opposed to a firearm. But generally, these things are a lot easier to carry around, with the one big caveat: police oftentimes do not know about this carve out of the definition of firearms. They treat it like a gun. These things get dismissed, thrown out of court, all those other things. But winning the battle, maybe you don't beat the ride, but anything to add to that?
Mix your metaphors. Yes.
I did.
Yeah. All right. Who's next?
All right. This one is kind of fun. I'm going to give you two because this first one's really fast. This is from P. Canala 3232. This was in response to Emily talking about how many times she gets pulled over by police officers. Question: what was the red Italian sports car? No need to mention how fast it was allegedly driven. Do those things have a mind of their own? Because Emily gets pulled over a lot. She used
not anymore.
Yeah.
No, they do have minds of their own. So Alfa Romeo, I don't even think they make them anymore, but they used to make a quadrifoglio version of their SUV, and
they have like a Ferrari engine.
did have they weren't allowed to technically call it a Ferrari engine, but if you
Sure.
looked at it and you looked at a Ferrari engine, they were identical and they were manufactured in the same plant. No, God, it was so fast.
Yeah, you got
It
pulled
was
over a
so
lot.
fast. I got
All
pulled
right,
over a lot.
same person.
Okay.
Actually, this is why it's a two-part question.
Uh,
Is there any circumstance under which you would opt for a bench trial other than a jury trial?
Ooh, I love this question.
This is going to
Yes,
start a lot of debate.
it is going to start a lot of debate. Yes. However, those circumstances are few and far between. And I would say for me, it comes down to two things. And then, Richard, you can chime in if you think
Okay.
any differently. But number one, you need to know your judge backwards and forwards, and you need to think highly of their intelligence. But number two, you need to have no question as to the applicable law. You have to know the law is on your side. And it doesn't hurt if you have really grisly facts that you don't want to take to a jury,
Right.
but know your judge and know that you will absolutely win as a matter of law, because you can't always trust juries with that, but you should, if you know and trust your judge, be able to trust them with that.
So the scenario that I imagine in is if you are going to plead guilty, but not have some kind of agreement on punishment. That's when you might have a punishment trial in front of a judge only, and this doesn't necessarily apply to like maybe self-defense cases, but it's kind of like a taking responsibility for things, trying to limit the amount of punishment that you get by taking responsibility. Also, the state is probably going to be less invested in a case if they've already got the guilty.
Yeah.
They seem to put less effort into punishment cases, just my experience. But it's really, if you have a punishment case as opposed to a guilt innocence case, that might be a scenario where you do it.
Yeah, I think we've had one client ever who I would have taken to bench trial if it had gotten that far.
Yeah.
And that was, you're going to remember this. There was a young man who was selling lots of drugs out of his home. Not a particularly nice young man, but another not particularly nice young man broke into the home with a gun and was going to kill him for his drugs. And he shot and he killed that guy.
Hate it when that happens.
Had that, now luckily actually they didn't even charge him. They investigated it. They charged him for the drugs.
Right.
They didn't charge him for the murder. But had they charged him for the murder, that's one I probably would have said, you know what? Let's take this to the bench, because he was not likable. And the facts were terrible, except that his castle was violated. He has a presumption that his use of self-defense was reasonable and that deadly force was reasonable. Bingo, bango, not guilty. And I'm not sure I would have trusted a jury to look past how distasteful this guy was, but the judge would have.
Right. And again, jury trial, if you are going to trial, you want a jury trial 99.9999% of the time.
Rare.
That's what you want. These bench trials
Yes.
exceedingly rare, and they really, it's going to be very fact specific.
Yes, of the hundreds or potentially thousands of actual clients we've had come through these doors
maybe
now,
one.
this is the only guy I can think of.
Yeah.
But all right, now to Richard at Artisan Absolute. I want to fly from my home in Texas to a non-reciprocal carry state, pick up a vehicle, and drive it home through more non-reciprocal states. The main reason is security and restrictions of safe carry regulations keep me from carrying in the cab. Can you talk me through how I might make this work?
It's probably not going to work. I hate to be the bearer of bad news. In order to, especially if you're going to a gun hostile jurisdiction, let's say they don't recognize your license or permit, okay? But let's say they go a step further and effectively criminalize possession of firearms by out-of-state residents, with exceptions, right? Hunting or something like that. You're probably not going to fit into one of those categories. And when we look at protections like the Firearm Owners Protection Act, and we have those three key components: legal possession at your start and finish, not ceasing traveling, and then the unloaded, encased, inaccessible kind of requirements. Well, here's the problem. When you fly to one of these hostile states, when you land there, you've ceased traveling for purposes of that law. And so you're not going to get the protection. Even if, you jump off the plane, run to the, luggage carrier, grab your luggage, run, jump in a car and start driving. I think a prosecutor would make the argument you stopped traveling when you landed.
Yeah.
Yeah, it's not a good place to be. We got this one to you, Emily. This is enter username, expletive.
Something.
Suppose a defendant decided to take the stand and bring up jury nullification in one of their answers. Do you think this would face any consequences from the court? Could it be seen as trying to subvert the jury instructions, thus contempt of court? I figured that could be a way for the jury to know about it without it coming from counsel. Because we were talking about jury nullification and how much trouble we would get in if we brought this stuff up.
Yes. So you might get away with that once.
Yeah.
However, the court is going to assume that I told you to say it. And I'm going to get my butt chewed.
Yeah, here's how I imagine it goes down in my mind. Judge says, "Excuse me, ladies and gentlemen of the jury, I need y'all to step out for a moment." They go out.
State's going to move for mistrial.
State's going to move for a mistrial. Judge may or may not grant it. If the judge doesn't grant it, they are going to ream the person testifying. They're going to ream the attorney.
Yes. Yes.
And then probably give an instruction once the jury comes back in.
Jury's going to come back. They're going to give a curative instruction. They're going to, the prosecutors, if they know what they're doing, they're going to move for a mistrial. The judge will deny the mistrial, and then they're going to move to strike from the record. They're going to move for the jury to be instructed to disregard. If they're really, really good at what they do, they're going to try to write their own instruction to be read to the jury as to how to disregard it, which is a trick Leslie and I learned in our last murder trial. We had a really cool judge who brought us into chambers after we won, which was great, but brought us in chambers and was like, "Hey, here's something I think you guys would be good at, and not a lot of people do it." And he was telling us how to write our own instructions for having things disregarded by the jury. It was great. But also, yes, the judge is never going to stop holding that against both the lawyer and the person who testified for the rest of trial. So, I mean, as a middle school teacher...
We don't say jury, we say schmullification. Yeah.
One time, a middle school teacher, two boys got in a fight in my middle school. It was a very, very small school, and I happened to sort of be in proximity when they got the one who punched the other one, took him out. And the teacher said to that kid, because everyone hated the kid who got punched, she said, "I hope you made it count." So that's what I'll say to you. If you are going to say the words jury nullification or allude to it in any way from the stand, make it count. Because there's a lot going against you after you do.
But we would never advise you to do that.
No. And for the love of God, don't tell me that's your plan.
Yeah. Oof.
Okay. All right. We have this one. Do you want me to, do you just want to talk through this one? It's not really a question, but I love this. This is someone who disagrees with us, but did so intelligently and respectfully that it is worth discussing.
Yeah, Edward 1250. We'll throw the whole question up there, but essentially, I'll get to the heart, the meat and potatoes of this are, guess what? We waive constitutional rights all the time. In context, we were talking about the gun buyback ban that we have here in Texas. He was brought up the point, hey, look, people waive their rights all the time. You waive your right to, think about right to a jury, right to speak to the police, to consent to search. Think about all of this. We waive our right to freedom. We go work at a job, right? So why not be able to give away firearms to the government? For me, I think it just comes down to, I don't think that's good use of taxpayer funds.
That's where it's different for me too. And I will say at Edward R 1250, this is, if you guys disagree with us, this is how you do it. And we'll take it up and discuss it, because we're lawyers. We don't mind when people disagree with us. Our entire being in our professional lives is, people often compare it to like if you were a surgeon, except there's another surgeon on the other side of the table trying to undo everything you're doing and kill the patient. That's what we do.
That's what we do.
We get disagreed with all the time. But when y'all are like, what do these so-called lawyers not understand about shall not be infringed? Well, we're not going to respond to that because it's not a real argument. We're telling you how the law
and we agree with you.
Out.
We're just saying that's not what the courts say.
Well, yeah. It's not helpful to sit around in a circle of shall not be infringed. Samir definitely bleeped that one. Because it gets us nowhere. What we're telling you is this is how legally in the real world things play out. And you might think we're wrong about something we're opining about. Let's talk about it. So I think this is very interesting. My disagreement comes from the fact that the government does not pay you to waive any of those other rights.
That's true.
And I think the monetary, because you could go turn your guns into the sheriff's
undermines
office.
voluntariness.
Yes, exactly. Like you could go turn your guns into the sheriff's office 7 days a week and twice on Sunday.
They'll take them.
They're not paying you. So if the government is offering you money to forego a constitutional right? If they said, hey, you have the right to remain silent, but if you talk to us, we'll give you $1,000. Never in a million years, never, because that's the equivalent here in my mind. Never in a million years would that pass muster. Same reason we're not allowed to pay people to vote the way we want them to vote.
Right.
Not allowed to pay people to like give you an organ, right?
Yeah, I don't agree with that law either.
New York doesn't let you be a surrogate. You
Oh.
can't pay someone to be a surrogate in the state of New York. I mean, there's lots of times in which, we sort of collectively as a society are like, yeah, you can't pay someone for that because it undermines voluntariness.
Yes, but the last thing I'll say is a part of these buyback, again, air quote, I roll, because, the government didn't own this stuff in the first place. These kind of waiver of we can't use this thing, or we promise to, bar ourselves from prosecuting you or any crime in connection to the firearm. That undermines public safety, which I think is a big issue.
Yes, absolutely it does. As does the idea that anytime you get guns off the street, everyone is safer.
Yeah.
That undermines, in a very fundamental level, undermines our public safety. But, okay.
Well, and we should probably do an episode on this. I don't want to say, it's like saying, it's getting quiet out there. Have you heard EMS talk about that? They don't say the Q word because then obviously emergencies happen. They got to go save people.
Oh, that's kind of like how we don't talk about how many calls are coming in on the hotline.
Yeah.
Yeah, no,
So,
fair enough. You don't tempt the universe.
No, you don't tempt the universe. But violent crime down across the United States. What's going on? It's interesting. But,
Sure enough.
all right, these are our favorite things to talk about. What I'll say, what helped a lot, putting the word question in your question.
Yes.
That really does help a lot when we're trying to find these things. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And leave your questions here. This is the first place we come when we look for next week's questions. Until next time, we're the Arms Attorneys.